WOL, Radio 1 Incorporated, or their management.
Good morning and welcome to Law Talk with Ethel Mitchell. Now for today's show, here's attorney Ethel Mitchell.
Good morning. Welcome to Law Talk with Ethel Mitchell on WOL 1450. A special welcome to my family, friends, colleagues, clients, and listeners throughout the United States and the Caribbean who are listening to us live on lawtalkwithethelmitchell.com, WOLDCnews.com, and through the app TuneIn. Welcome. Since this month is especially dedicated to love, each program this month will explore how law impacts affairs of the heart. Last week we talked about prenuptial agreements. It was hot. And in case you missed it, or you know someone who ought to hear it, you can listen to that show on lawtalkwithethelmitchell.com by pressing the YouTube link. The law is such a powerful force in each of our lives. It impacts everything we do. What you don't know about the law can hurt you. What you do know about the law can empower you. My aim is to empower you by bringing you professionals to tell you how the law impacts you and your actions. Love can be gentle, but it can also be difficult to navigate. Law Talk with Ethel Mitchell continues to empower you with experts and resources. This week we're talking about the law and how it impacts and applies to people who live together without the benefit of marriage. Next week, Law Talk will have attorney Sharon Theodore Lewis to talk about the many, many legal benefits of being married. We want you to be part of the conversation. My executive producer, Stacy Royster, is standing by to receive your calls and pass along your tweets. Write this down. Call us at 1-800-450-7876. That's 1-800-450-7876. Tweet us at LawTalkEm. Talk to us on Facebook at Law Talk with Ethel Mitchell. Let's get started. How many people do you know who are not married but live together? Maybe even you. If you are in a relationship and are living together or thinking about it, you need to listen closely to today's show. According to the U.S. Census Bureau, in 2012, there were 103 million unmarried people in the United States who are 18 and older. 56 million U.S. households were maintained by unmarried men and women. That's over 46% of households nationwide. In 2011, there were 6.7 million unmarried partner households. Of this number, 605,000 were same-sex households. What, if any, rights do people in such a live-in situation have with respect to property, to money, to business interests, to act for their companions if they become incapacitated? If you are in a live-in situation or thinking about going into one and not married, you need to get educated about your rights in a live-in situation. But first, I must remind you that what you hear on this program is for information purposes only. No attorney-client relationship is established by anything said on this show. Each person's circumstances are different. You must seek individual counsel for any situation you need legal advice about. Now, attorney Michelle C. Thomas is back with us again. She was so great, I asked her to come back to enlighten us about this subject. Attorney Thomas is a divorce strategist, founder of MC Thomas and Associates PC, a complex divorce and family law firm serving Washington, D.C., Maryland, and Virginia. Attorney Thomas's articles have been published in the Washington Examiner, Washington Times, and Essence Magazine. She has been a guest on Law Talk with Ethel Mitchell before, in fact, our first guest on our inaugural program. She's been a guest on Fox News Television, The Audrey Chapman Show, and more. Michelle, we all know people who cohabitate with their significant other, or shacking as some called it. Help us to understand the legal status of people in an undefined live-in situation. What rights, if any, does each person have in such a situation?
Well, good morning, Ethel, and thank you so much for having me back. I really enjoyed the show last week. When you're talking about couples who are living together without any type of legal status, meaning they're not married, they're not domestic partners, not common law married, or anything along those lines, then the legal rights become a little ambiguous. Basically, without an agreement in place, you're going to be like two litigants in any other situation fighting over property, what belongs to whom, and you really don't have the protections of the law that apply to other persons who are married or in common law type marriages.
Okay. You all hear that out there, okay? You don't have any protection to speak of. Tell me, what rights, let's start with basics. Suppose they have a joint bank account. Bank account, savings account, anything that is in both of their names. What rights do each of them individually have in that joint property?
In a situation with a joint bank account, just like with any other property, it really depends on how it's titled or how the two people hold the account. So, for example, if you're not married, you likely will hold the account as joint tenants, as opposed to tenants by the entireties if you are married. And those are some legal concepts. So I always say, whatever you do, consult with a lawyer because it can get a little complicated.
Yes.
But in terms of the rights, if you own an account jointly titled, either one of you can take money out of the account. And so the problem becomes, how do you recover that money if you don't have the protections of the law that apply to married couples?
Even with married couples, though, if it's a joint account, you might be out if that person takes that money out. Isn't that correct?
That is correct. But with a married couple, if you were to file for divorce or to seek protection from the court can, in fact, order that money to be paid back. And there are various protections that apply that say that the money belongs equally to both parties or should be equally divided. And there may not be that presumption of an equal division of the property if you're not married.
Right. And isn't it also true that if someone else's name is on your bank account, their creditors can get to that money?
Absolutely. You certainly run the risk. And, dating and being together is all fun and games, but people don't ask enough for a credit report before they decide to move in with someone. And so if your partner has creditors or a bad credit history and creditors are calling in after them, your money becomes their money and ultimately can be taken.
And when the creditor goes in to get it, do they take 1/2?
Oh, no. The creditor will take exactly what they believe is owed to them. And so if your partner put in $1 in that account and you put in $1,000 and the creditor is owed $1,000, guess what? $1,000 is gone.
So all of it, the law considers that you own everything that's in a joint account.
Yes.
Yes. Okay. That's an important fact, listeners, that a lot of people don't realize. In a joint account, regardless of who puts the money in,
right,
the law presumes that each of you owns all of it, and therefore both of you can take everything out of that joint account, as well as your creditors.
Right. So without an agreement in place, there's no liability, limitations on the liability that you face if your partner gets into some trouble. So be careful out there who you decide to move in with and who you decide to share bank accounts with, because you can get more than what you expected.
Yeah. Or lose more than you expected.
Or lose more than what you expected. Right. Exactly.
Okay, let's talk about homes. What happens if one partner owns the home? Their name is on the deed. There's usually a mortgage.
Yes.
And both of them help to pay the mortgage.
Yes.
What kind of rights does the person whose name is not on the deed have to whatever their interest might be, if any, because they paid the mortgage? Do they even get an interest because they paid the mortgage?
If you're not married and don't have an agreement, very little. And that's
you all hear that? Very little. That's important.
The person's name that is on the deed owns the home. And so, unlike in a marriage situation where you may have an equitable interest in ownership of the home, or certainly a marital and legal interest in the home. If you're not married and just living together, the person whose name is on the deed is going to keep the home. And so you may try to sue them to try to recoup some of your money, but that just creates a tangled web that's unnecessary if you are actually married.
So are you saying that even if you do a major renovation, like a lot of people have lived together for a long time, in fact, there was an article in the Washington Post recently where they talked about a couple who had lived together for a while. They wanted to take out a bigger mortgage to refinance. The person was going to put money into it, and they were concerned. I mean, is there any kind of provision if you don't put the person's name on the deed?
Well, you may find yourself embroiled in litigation and civil actions being filed against you from the person who invested what they consider whether it's time, money, sweat equity into the renovations of the home. But it's really an uphill battle because, again, without an agreement in place, the homeowner is the person who is on the deed, and not the person who is living there and sort of giving money freely and voluntarily to help maintain the home.
Does it make any difference if they've been living together for a long period of time?
Well, it depends. It depends because in some jurisdictions, such as the District of Columbia, you do have a scenario like common law marriage. And so if parties are living together under certain circumstances, then they may have an interest and they may have legal rights that arise. But just living together for a long period of time without any intention of holding yourself out as being married does not convert the property to your property, to joint property.
Right.
And I think enough people don't know that, and if they did, they might consider more readily entering into cohabitation agreements that lay out who is entitled to what property if the relationship dissolves.
That is so important. Ladies and gentlemen, please listen up and call us. Tweet us. We want to know what you think about all of this. We're going to get into common law marriages in a little bit, but tell me also, what about cars and other expensive items? I have clients that come in, and does this make a difference? They say, well, we put everything in one person's name because they had better credit. I had bad credit.
Right.
And so we didn't put the car in my name for that reason,
Yes.
Does that make any difference if you're not married and you don't have anything in writing?
Yeah, it really doesn't. So the car also belongs to the person who's on the car note and who is on the title to the vehicle. And so a lot of people, after many, many years of living together, and they may feel like they are married, but without a piece of paper that's a license that says you are, or some other circumstances that create a common law marriage, you might be out of luck down the road.
So are you saying, Michelle, that people can put you out of a house that you've lived in for years?
Unfortunately, that can occur. And if you're trying to sort of recoup what you've put into it, you may end up in litigation. But there's no laws that take effect just by virtue of you living together.
Wow. So listeners, please call us at 1-800-450-7876 or tweet us at LawTalkEm. This is very good information for anyone that is in a live-in situation. Let us know what you are thinking about, but let us continue. Let's suppose that there is a business that one or both of them have. They're living together. They either may start a business together, or maybe the business was already in existence, but the business is owned legally by one party as opposed to both parties. But both parties are working in it. Both parties are building it. Tell us, what are the rights with respect to that, the business value that's built up during this relationship?
Well, with respect to a business, typically you're going to have bylaws, articles of incorporation, organization, things along those lines. So the business documents would govern who takes what at the end of the day. Should the business dissolve, or should one person decide to leave the business? But if you are working in the business as in the capacity of, say, an employee, then you have the rights that would be attributable to an employee. You don't get a chance to take the business equity out of the business by virtue of the fact that you've lived together. that does not translate over as it would if there was some sort of marriage in place.
Okay. And so if you're not married and you're helping to build somebody's business and you don't have any ownership documents, i.e. shares or stocks in your name,
right,
or you don't have any membership units in an LLC, for
right.
example, or any other kind of agreement, you could be put out and just with your salary and be done with it?
That's pretty much how it works because, people think that by living together, someone may feel like they're vested and they've dedicated so much and they've worked so hard for it. And the bottom line is this. You need to have everything in writing. That's really what it boils down to. So if you're choosing a cohabitation type of situation, that's fine, and certainly you're welcome to do that. But at a minimum, you need to put into a contract, whether it's a cohabitation agreement or bylaws that govern how the business will operate, you need to put it in writing to protect your interests. The worst thing you can do is to spend 10, 15, 20 years with someone, devoting your life to that person, and at the end of the day come up empty-handed. And you can avoid that by simply putting things in writing.
That's good information. And listeners, I hope you will pay attention to this because this is important. Another very important dimension to today's subject is 40% of opposite-sex unmarried partner couples in 2012 live with at least one biological child of either partner. What happens when children are involved? How should everyone be protected?
Well, children, that's a really sensitive and interesting subject because, as everyone knows, sort of the best interest of the child is always at present, and that's always at issue in any type of custody proceeding. The problem with living together with a child unmarried is that without an agreement in place, what we call a custody or co-parenting agreement in place, either parent can take the child and leave, and there's nothing you can do about it in the immediate moment. So if you call the police and there's nothing in writing, there's no court order that says who is going to have the child when, they can't go and pick up your child and bring them back. You have to file in court, get an emergency, or file for an emergency motion, and there's really a lot there that can and should be avoided by just having a co-parenting agreement in place.
And that's true even if the child is the biological child of one partner?
If the child is the biological child of one partner, then
but the partner lives with someone who is not their
if the other parent
child
is not the biological parent, then no, only the biological parent has the rights to the child. If that's
I wanted to make sure about
the question.
that.
Yes.
Okay, but in the work that I do, doing wills and trust and so forth,
yes,
a lot of children are raised by non-biological parents,
step-parents, so to speak.
and they expect to inherit from these step-parents. And they don't.
Yes.
Okay. Or the step-parent expects that child will take care of them, and there's no legal obligation there unless there's something in writing.
There is no legal obligation there, and the law makes no distinction between biological and adoptive children or adopted children. But if the child is a step child, then you really are no different than any other person. Now, you may be able to file something in court for visitation rights or things along those lines, because if you've raised a child from, say, birth until 10 or 12 years old, then you would be considered a person with a legitimate interest in that child. And so as sort of a third party with a legitimate interest in that child, you may have some rights. You may be able to still be able to interact with that child, but you have to file something to do that. You would not be able to just take the child whenever you so choose.
Okay. I do a lot of work with blended families.
Okay.
And that's one of the primary things that we try to take care of, where step-parents want their stepchildren to inherit and vice versa.
Okay.
Where those are the people that they trust with their money and so forth like that. So I prepare a lot of power of attorneys, a lot of wills, a lot of trusts to make sure that those kind of things can happen. So we are talking with attorney Michelle C. Thomas right now. And I want to go now to domestic partner relationships. What is a domestic partnership agreement? And how is that different from marriage or, traditional notions of marriage?
Right. So the concept of domestic partnership is an interesting one, and one that does not play out in every state. So you have to check certainly where you reside to determine if your state even recognizes or has allows for domestic partnerships. But here, for example, in the District of Columbia, couples are allowed to register as domestic partners. And in order to do that, you basically have to certainly be over the age of 18, have the mental capacity, not be married to anyone else, and you have to be living with the partner that you're going to register as. So a domestic partnership is a process where you register with your state or jurisdiction as domestic partners, and then you become entitled to various legal benefits as a result of that.
Okay. We're taking. I'm going to rush you a little bit because I also want to get to common law marriages.
Oh, okay.
Okay. What is a common law marriage and how is it established? And is it recognized in all three of the major metropolitan areas here in the states here?
Right. So common law marriage is a concept of persons who are living together with the intent to be married, who hold themselves out to the public as husband and wife. And you have to be living together for a significant period of time. A lot of people commonly assume that 7 years. It's not necessarily 7 years, but it does have to be a substantial period of time. Okay. So in the District of Columbia, yes, common law marriage is in fact recognized if you take certain steps like I've discussed. In the surrounding sister states, Maryland, for example, you cannot create a common law marriage by living together and holding yourself out as husband and wife. But Maryland does recognize common law marriages established in other jurisdictions, such as the District of Columbia. Okay. And Virginia certainly does neither.
No. Okay, so you're out of luck.
Yes.
Okay. So you said something, and I want you to repeat it because I think it's really important. You have to hold yourself out as husband and wife.
Yes.
What do you mean? I mean, is that a specific requirement of a common law marriage?
That is an absolute requirement of common law marriage. And so let's be clear, living together for 10 years, 15 years, 20 years does not by itself create a common law marriage situation. When you go out to public events, you need to introduce each other as husband and wife or as spouses. Okay. You need to show up and when you complete papers for either your children's schools or jobs you're applying for, anything along those lines, you need to represent that you are married and that you have a husband, wife, or spouse. Okay. So that is what's required. Just living together. And if everyone knows that you're long-term partners or boyfriend and girlfriend or whatever it is, that is not enough.
Okay.
To create
because
a common law marriage.
There are a lot of people that have been living together for a long time. The children call them uncle and auntie.
Yeah, and
they,
yes.
People know that they've been together forever.
Yes.
All your life in some
Yes.
instances. And yet when one of them dies, you find out, well, they're not really married.
You find that out very quickly when someone is sick because you don't have the rights to visit or access a person in the hospital. You may not have the health directive rights if you're not considered married. You certainly find out in terms of an inheritance. You don't automatically receive the inheritance from the other party.
In fact, if you're not married under some kind of either common law or traditional notions of marriage,
right,
you don't inherit as a spouse.
That is correct.
And that's important for people to know.
That is absolutely correct.
And you can't be a little bit married. Either you're married or you're not.
You are married or you are not.
Yes.
So let's be clear.
Let's be real clear about that. Let's be real clear about
living
that.
Living together, he can call you, sweetie, baby, anything that he wants and sweet talk you until the cows come home. That does not mean that you are considered married and that you have the legal entitlements of marriage.
Okay, I want that to be very, very clear, because another thing that comes up a lot is sometimes people are already married, they never get divorced, and then they try to establish another either relationship or marriage.
Absolutely not possible.
Not possible.
Not at all.
Okay, so ladies and gentlemen, when you are out there thinking about marrying somebody and you know that they have been married before, I recommend you see the divorce paper.
And, and it's unfortunate that we have to put it out there like that.
Yeah.
But today, please do your due diligence. That's what we call it in the legal profession, conducting due diligence. Please do that and make sure that there is a divorce decree signed by a judge.
Yes.
so
that you have seen.
So that you have seen.
And you know. Because
Yes.
it happens all the time. People
Absolutely.
say they're married. Sometimes they actually think they are divorced.
And that's true too. That may happen, or someone may just, now have been paying attention. So, do your due diligence. Make sure that all of your ducks are in a row so that if you're trying to create a common law marriage, that you will actually be able to reap the benefits of marriage as a result of that.
Yeah. And next week we're going to talk about what those legal benefits are that the law gives to married couples.
Right.
Okay?
And there
because
are many.
There are many, many benefits that are available for those who are married. I hope that you all have been listening and that you will tweet us or send information to us about this subject. I want you to be in touch with Attorney Michelle Thomas, Michelle C. Thomas, at her website, thomaslawdc.com.
Yes.
Okay? And I'd like you to call her at 202-536-4841. It is really, really important for all of you out there who are either in these situations or considering going into a situation where you are live-in. If you think you're in a common law marriage, it is worth it to find out if you are or you are not.
Absolutely.
It's really critical. Michelle, what else would you like people to know? We've only got another minute left, but this has gone very fast.
Sure.
It's a lot of good
It's
information.
a lot of information and a lot to cover in a short period of time, but much of the costs and uncertainty can be eliminated if parties have a written agreement in advance, whether it's a cohabitation agreement or a prenuptial agreement, any kind of agreement that you can just put into place in writing.
Yes.
Will help to eliminate a lot of ambiguity and certainly duress and heartache down the road.
Heartache and hurt in your pocketbook too.
And absolutely.
Okay? And whatever agreement you have can be changed also with the mutual agreement of the parties later on.
That is true too. They always say it's cheaper to keep her.
Yeah.
And that becomes true if you don't have an agreement in writing.
An agreement in writing.
Yeah.
Okay. Well, I hope you've enjoyed this program. I would really appreciate it if you went to Facebook, Law Talk with Ethel Mitchell, and give us your comments. Contact Attorney Michelle C. Thomas, as we said before. Contact me for getting your wills, your trust, your power of attorneys, and health care directives done, and your estate planning needs. I also work with estates, probating estates. I am Ethel Mitchell. Next week, come at 11:30 to noon, where we will talk about marriage and what legal rights are there. Get educated. It's about you. Understand how the law applies to your life from the cradle to the grave. I'm your host, Ethel Mitchell, and this has been Law Talk with Ethel Mitchell. Have a good day.
You've been listening to Law Talk with Ethel Mitchell. Be sure to tune in next Saturday at 11:30 a.m. for another informative broadcast. To reach Attorney Mitchell, you may do so by calling 202-772-1988. That's 202-772-1988. Or log on to her website, www.lawtalkwith